Good morning, good afternoon, good evening, wherever you may be, and welcome to this webinar on international criminal justice in the contemporary Asia-Pacific region, sponsored by the American Society of International Law. My name is Meg de Guzman, and I am a professor at Temple University, specialized in international criminal law. I'm also a judge of the International Residual Mechanism for Criminal Tribunals, although I'm here today in my capacity as a professor at Temple Law School. It's my pleasure to moderate this panel, which has several very eminent speakers. And I'm going to start by just introducing the topic briefly. But before I do that, I want to thank especially Su-Hong Yang for putting this together and also for organizing an excellent conference in Hong Kong back in September that a number of us had the real joy of participating in on this topic. And that conference sort of gave rise to this follow-up webinar. So thank you, Su-Hong, for all of your incredible organizational efforts. So the Asia-Pacific region, one of the world's most diverse and dynamic regions, remains the most underrepresented at the International Criminal Court. The region presents a complex and evolving landscape for international criminal justice, characterized by historical conflicts, diverse legal traditions, geopolitical tensions, and varied engagement with global justice mechanisms. In our webinar today, we'll discuss various perspectives on international criminal justice in the region, with a focus on contemporary practices and approaches, including Asian international criminal institutions and general principles of international law, as well as the 2024 amendments to the International Crimes Tribunal Act of Bangladesh, domestic implementation of the Rome Statute in Pacific countries, and China and the International Criminal Court. I'll first introduce all of our speakers before turning it over to them. And I also want to say at the beginning that participants, please think of your questions as we go, because we will reserve plenty of time at the end. We have an hour and a half, so we're hoping to reserve close to half an hour for Q&A engagement with you. So please put your questions in the Q&A function as they occur to you so that you don't lose track of them and we can start thinking about them. So our first speaker will be Megumi Ochi, who is an associate professor at the Graduate School of International Relations at Rimsu Mikan University in Kyoto, Japan. Hopefully I didn't butcher that, Megumi. She has published 3 monographs in Japanese. The English version of her second monograph was recently published as The Premises of International Criminal Procedure, Identifying the Principles in International Collaboration by Springer. Her paper for today's webinar is How the Asian International Criminal Institutions Recognize the General Principles of Law, and it introduces the core theory developed in her books, which she has called premise theory, and discusses research findings that apply this theory to the practice of international criminal justice institutions in the Asia-Pacific region. Tanisha Vaid will be our next speaker. She serves as legal counsel at the Presidential Court of the United Arab Emirates and has represented the UAE before international courts and tribunals, including the International Court of Justice. She's licensed to practice law in New York and India and specializes in public international law and investment arbitration. Her prior experience includes roles at the International Court of Justice and the International Monetary Fund, as well as work in international criminal law with the International Crimes Tribunal of Bangladesh. Her paper, Dressed for Legitimacy, the International Crimes Tribunal in Bangladesh's Attempt at Reinvention, examines the tribunal's evolving legal framework with particular focus on the 2024 amendments to the statute. Next, we'll hear from Daley Burkett at Birmingham University in Dubai. He is associate professor and head of department for Birmingham Law School in Dubai. His research on international criminal law and public international law appears in leading journals, including the Leiden Journal of International Law, the Journal of International Criminal Justice, and the Chinese Journal of International Law. He jointly received the 2020 Journal of International Criminal Justice Prize for his article, Managing Frozen Assets at the International Criminal Court, the Fallout of the Bemba Acquittal. Beyond the Academy, he has served twice as legal consultant to the United Nations, assistance to the Khmer Rouge trials, advising the international judges of the Supreme Court chamber. Daly's paper examines how states parties in the Pacific region have implemented the Rome Statute of the International Criminal Court in their domestic legal systems. And last but certainly not least, we'll hear from Su-Hong Yang, who is a global academic fellow at the Faculty of Law at the University of Hong Kong. Her academic interests include international criminal law and international dispute settlement. She is currently vice chair of the American Society of International Law's International Criminal Law Interest Group and also simultaneously secretary of ASIL's Women in International Law Interest Group, which I had the pleasure of co-chairing and working with her for a couple of years, which was great. She holds an SJD from Georgetown University Law Center and was a judicial fellow at the International Court of Justice. Su-Hong's presentation focuses on China and the ICC. So without further ado, let me turn it over to our first speaker, Megumi Ochi.
Thank you for the introduction. I would like to first share my PowerPoint slide. I hope everyone can see it clearly. Yes, thank you so much. Hi, I am Megumi and working at Ritsumeikan University in Kyoto, Japan. And now here it is 11 p.m., but I am extremely honored to be presenting in this webinar series of ASIL. Today, I will talk about how the Asian international criminal institutions recognize the general principles of law. And to do this, I will introduce my original theory called premise theory. So first of all, I will introduce the Asian international criminal justice institutions in general. International criminal justice institutions are in this presentation those courts, hybrid or domestic, with specific jurisdiction over core crimes, and those make references to international law. 3 such institutions exist in Asia Pacific in 21st century. International Crimes Tribunal in Bangladesh, ICT, Extraordinary Chambers in the Court of Cambodia, ECCC, and the Special Panel for Serious Crimes, or Untied East Timor Panel, SPSC. The research interest in the jurisprudence of Asian international criminal institutions is quite limited. And this may be because of the bias that we have, probably due to the image of political interference or the corruption scandals. However, how Asian institutions recognize laws is unknown to us, especially unwritten international law, including general principles of law. So therefore, against this backdrop, this presentation examines how Asian institutions recognize general principles of law. Well, the structure of my presentation is twofold. First, it reviews existing theories of recognition of general principles of law. Second, it applies premise theory to examine the Asian practice. So now let me overview the theories of recognition of general principles of law. So the main problem with respect to the recognition of general principles of law was how to adjust the domestic principles to international settings. Here is a general brief overview of the development of theories. During 20th century, scholars like Lauterpacht noticed the gap between national private law analogy, and Pele explored the cases in which national law had been transposed onto international law. While this theory of transposition, I think, which also appears in the contemporary textbooks, was being developed, Bin Chen empirically pointed out that the even International Court of Justice generally asserted the existence of principles in international law, irrespective of their correspondence to principles pertaining to municipal law. In 2000, the scholars started examining the practice of ad hoc tribunals, observed and called it as sampling and falsification methods, or vertical and horizontal move. Then in recent years, Ellis in European Journal of International Law, was of the view that the widely understood transposition methodology involves 3 steps: identifying a principle common to municipal laws, distilling the principle's essence, and adjudicating the principle to be applicable to international legal settings. Meanwhile, in 2010s, scholars criticized the practice of ad hoc tribunals such as ICTY and ICTR as pragmatic or even chaotic. More recently, for the ILC report, Special Rapporteur declared so-called two-step approach, and I think this is one of the most prevalent, like the prevalent approaches that we all learn at the classes. First, determining the existence of a principle common to the principal legal systems of the world. Second, ascertaining the transposition of that principle to the international legal system. However, I would like to say that this approach lacks an insight from the practice, especially the practice in international criminal adjudications. So the premise theory that I am proposing is based on the analysis of more recent practice of the ad hoc tribunals and even the ICC. It reveals the four-fold formula of recognition methods. In these cases, general principles are adopted by taking into account the premises of the field of law to which they are to be applied, or the premises of even the chamber or the case. And they do it by modifying the common elements of existing principles, I call modification approach, by selecting from existing principles, what I call selection approach, by modifying a selected existing principles, a two-stage approach, or by adopting new principles appropriate to such premises. So the premises here can either be factual constraints a court cannot avoid, such as procedural structure or institutional mandate. And it can also be normative values the court aims to uphold, such as human dignity or fair trial rights. Premise theory can explain the determinant behind the judge's decisions and thus shift the focus from arbitrariness to determinant. Applying this lens, this paper examines how the Asian institutions recognize general principles, what premises guided their decisions. So now I'd like to start introducing the result of my findings. Before that, as preliminary matter, I am explaining how international law is relevant to these courts. Actually, all 3 institutions allow reference to either recognized principles and norms of international law, international standards of justice, or international references. And adding another layer of analysis lenses, I introduced the concepts of pioneership and followership in citation. In the previous papers submitted to the conference that Meg mentioned, that was held in Hong Kong, I presented the framework borrowed from global governance studies about pioneership and followership, and developed a research framework of citation as followership. In this framework, International Military Tribunal or ad hoc tribunals or ICC are all recognized as pioneers, while Asian institutions are often followers. Asian institutions' followership is either passive, active, or proactive by accepting the previous jurisprudence, by ICTY or ICTR, conducting original recognition activity, or recognize different or new general principles. So now I'd like to introduce my findings. Through systematic manual review of judgments, I found a handful of cases where the judges attempted to find the general principles of law as unwritten external reference. This is a table that I'm developing, and I have not finished reviewing all judgments available, and this is a work in progress. But so far, I have found, I have 3 interesting observations. First, I found it interesting that common factual condition of retroactivity led them let all three institutions follow ad hoc tribunals on norm crimen sine lege, or principles legality. Second, the crime of rape as crimes against humanity required general principles of law, just as for ICTY. And third, ECCC had potential to become pioneer. Now, I will explain the findings in the following slides. First, I found several interesting cases that reflecting factual condition as critical premise to recognize specific format of norm crimen sine lege. The factual condition for all three institutions is their retroactivity. SPSC, the East Timor panel, was established in 2002 and tried cases that occurred in 1999. ECCC and ICT in Bangladesh, both established in 2000s, and tried cases that occurred in 1970s. They all needed to examine the valid contour of norm crimen principle, and they just followed ICTY's framing, namely that they only have jurisdiction on crimes that were criminalized under customary international law at the time of the commission of the act. Other remarkable cases are found in relation to the definition of rape as crimes against humanity. Both SPSC and ECCC had to determine the criminality of rape as crimes against humanity. While the SPSC referred to the book written by Professor Bassioni as main reference, ECCC conducted its own comparative research of domestic law in 1970s. ECCC took the view that proscriptions against rape at the municipal level are insufficient to show the emergence of rape as a category of crimes against humanity by recourse to the general principles of law recognized by the community of nations. And it concluded that given this lack of support under international and municipal law for the existence of rape as a distinct crime against humanity during the ECCC's temporal jurisdiction, it was an error in law in concluding that the rape in question is a crime against humanity prohibited under customary international law. Then I started wondering that ECCC should be categorized as pioneers in certain issues. While SPSC and ICT have hardly ever conducted detailed comparative analysis of domestic laws, for these cases, the ECCC compared the domestic laws that were applicable in 1975 to 1979, over which the ECCC has jurisdiction. ECCC recognized a different principle from that of the ad hoc tribunals on JCE3, based on its own research comparing the laws of Australia, Bermuda, Botswana, Canada, Fiji, Israel, Kenya, Malawi, New Zealand, Nigeria, Papua New Guinea, Seychelles, South Africa, Tanzania, Uganda, Western Samoa, Zambia, and it added also Egypt, Iraq, Uruguay, France, Bangladesh, Cambodia, Greece, India, Japan, South Korea, Thailand, and USSR. And it said that at the time relevant to the charges in the case at hand, liability as JC3 was limited to crimes that were actually encompassed by the common purpose. So it's a remarkable comparative analysis that was conducted by the judges. Similarly, ECCC recognized new principles. In Q case, based on comparative analysis of pre-1975 legal systems, both civil law and common law, including domestic laws of the Netherlands, Germany, Italy, Australia, Switzerland, England, India, Austria, USSR, and Japan, in contrast with French and Cambodian law as exceptions, the trial chamber recognized dolus eventualis as a general principle of law applicable to the crime of murder, including within the context of crimes against humanity in 1975 using selection approach. And in the same case, the chamber briefly reviewed the domestic laws of Civil and Commercial Code of Thailand, the Hindu Marriage Act, Special Marriage Act of India, Personal Status Law in Iraq, the Code of Personal Statute of Tunisia, the Law of Marriage Act of Tanzania, the Marriage Act of South Africa, the Matrimonial Cause Act of Nigeria, the Civil Code of France and Belgium, the Matrimonial Causes Act of England and Wales, and Civil Code of Spain, Brazil, Mexico, and the Family Code of Costa Rica and Cuba. And it concluded that domestic laws in both civil and common law jurisprudence jurisdictions in 1975 to 1979 established that marriages entered into either without consent or through coercion were either void or voidable. So now I would like to conclude. Through the case law analysis, this paper introduced that the recognition of general principles of law by Asian institutions shows several features, including the common factual condition of retroactivity let them follow ad hoc tribunals on norm crimen sine lege. The crime of rape, as crimes against humanity, required general principles of law, and that ECCC had potential to become pioneer. Why the ECCC was quite keen about finding its own general principle of law, while SPSC and ICT were not, may be relevant to their normative premises. ECCC may have had more visibility and aspiration to be regarded as international court, but I would like to leave this point to the future research. So the findings at least suggest that this jurisprudential followership may play a role in identifying and affirming universally applicable principles and their mechanisms in international criminal law. So this is the end of my presentation. Thank you very much. And if you like the presentation, please visit my homepage to access my previous books and papers. I would put the link to the chat. So if you couldn't get it, you can find it on the chat tool. Thank you so much.
Thank you so much, Megumi, for elucidating some of those important ways in which the Asian institutions have interacted with general principles. And now I'm going to turn it over to Tanisha.
Thank you, Meg. And I should say thank you, Megumi, for setting it up, because I feel like with the International Crimes Tribunal, the setup is always a bit tricky, because I feel that it's one of those atrocity or redressal mechanisms that is often quite misunderstood. Those that have heard of it don't fully understand it. Those that have dared to research it also do not fully understand it. So let me just begin. I'm going to try to share my screen. Okay. Maybe I'm going to continue without it. Actually, it's better. But let me just give an overview of what exactly the presentation really is about. So I too had the pleasure of presenting my work during the Hong Kong conference that Hong Kong University and Su Hong organized earlier this year. And my paper is basically discussing the International Crimes Tribunal Bangladesh, which was a tribunal set up pursuant to the ICT Act enacted in 1973. The tribunal was really conceived as a mechanism to essentially end impunity for crimes that were committed during Bangladesh's War of Independence, and to serve as a tool of, and which I think it continues to do, is serve as a tool of restorative justice for the period. Now, what I find quite striking with regards to this institution is that it was a bold idea that was pieced together at a time when the notion of domestic tribunals taking up the cause or the ownership of international crimes prosecution was virtually unheard of. It came up in the 1970s, where you have the infamous period or period of silence, and where international collective action in response to international mass atrocities was basically negligible. But what was very unfortunate in the case of the ICT Bangladesh was that it took a very long time, nearly 40 years, for that vision to take shape. So we see that the tribunal or the underlying act is enacted in 1973, but between 1973 and 2010, there's no tribunal that's been established pursuant to the act, and essentially no trials have been undertaken, commenced pursuant to the act. And one of the reasons behind this delay was essentially due to political turmoil and successive military coups that plagued Bangladesh in the years after its independence. So where that leaves us is that in 2010, you have Sheikh Hasina, and for background, she is the daughter of the founding father of Bangladesh. She comes into power and her government really sets up the tribunal. It operationalizes the tribunals and the trials begin. As Megumi alluded, they already had this problem back, in the 70s during its conception, but then again in 2010s on the issue of nullum crimen sine lege, retroactivity. The core focus remained in the practice of the tribunal, both in terms of the cases that are brought to the tribunal, but also the focus of the judges on the crimes that were committed during the 1971 war. So the mandate of the tribunal included crimes such as crimes against humanity, genocide, war crimes, crimes that are recognized under custom. But the application was quite narrow. It remained to the set of atrocities that were committed during the War of Independence. And we see this in several judgments throughout the course of the tribunal's functioning. You have what we call the Molla judgment. It was one of the first few judgments that came out where the tribunal emphasized that, yes, it's international. It has international in its name, and it remains international in terms of the crimes it prosecutes. But the focus in the application firmly remained anchored in the events of 1971. And this orientation is quite important because it dramatically changes in 2024. So in mid-2024, we see Sheikh Hasina, who's still in power, herself gets accused of committing crimes against humanity, arising from her government's crackdown of a student-led protest in Dhaka. Now, it's the escalation from there on that ultimately drives her into exile in India, where she still remains. But what we see is that she undergoes an in absentia trial before the ICT Bangladesh, which begins in August 2025 and interestingly concluded yesterday with the tribunal imposing death penalty after finding her guilty on 3 counts. And those counts include incitement, along with ordering to kill and the failure to prevent such acts. Now, the critics on Sheikh Hasina's side have basically argued that her trial was marred from the outset, and they point to these rapid and sweeping developments and restructuring of the tribunal that's happened in the last 1 year. This has included an overnight replacement of the entire bench, reconstruction or reconstituting, I should say, of the entire prosecutorial team. You have, and most importantly, the adoption of controversial amendments to the ICT Act, which is pushed through by ordinance. There's a lot of concerns as to whether passing such amendments through ordinance rather than act of parliament is within the constitutional remit. And I'll turn to these amendments shortly, but this overview is just to situate or give the background to precisely why this moment where we see this reconvergence of political rupture along with international institutional reinvention, I should say, has prompted me to look into this topic again. I was at the tribunal, as Meg introduced, back in 2016-17, and for the longest time, you really heard nothing from the tribunal. There were few individuals who were researching it. There were academic pieces coming out, but really nothing was being spoken of either in the news or in the international criminal law circles as the groundbreaking jurisprudence or any changes from the institution. So it pretty much was in this dark space in the lowest drawer. But it's really these changes in the last year that have brought it to light, both domestically and internationally, and reinfused energy into the tribunal. Now, the working title that my paper adopts is Dress for Legitimacy, the International Crime Tribunal Bangladesh's attempt at reinvention. And I really try to draw on the parable of the emperor's new clothes. And the analogy to me felt apt because the the research is being done at a time or in a climate when legal experts are publishing anonymously out of fear of persecution. And those of us that do, in fact, dare to write on the subject, in some ways are like the child in Andersen's tale that's pointing out to what appears to be quite obvious, that the emperor may in fact have no clothes. And in my research, I examined the tribunal's supposed new garments, these reforms and amendments that have taken place since 2024. And I come to the conclusion, or I'm heading to the conclusion, I should say, that these changes, in fact, do very little to conceal the enduring vulnerabilities in the overall structure of the ICT Act. Now, with that background, let me turn to just highlight a few amendments to the ICT Act, which I found quite interesting. And before doing that, I should maybe say at this stage that the ICT Act is no stranger to amendments. There have been multiple rounds of amendments through the course of its life. But it's these changes which the interim government has introduced that are arguably the most far-reaching to date. So for the purposes of this presentation, I've divided these changes or the amendments into three main buckets. The first bucket, I would say, relates to provisions that expand the tribunal's jurisdiction. The second bucket relates to provisions that align the ICT Act more closely with the Rome Statute. And the third one relates to provisions that introduce much needed procedural safeguards along with transparency measures. So in the first bucket, we see that the tribunal now has extraterritorial reach over Bangladeshi citizens abroad. And while extraterritoriality in and of itself is not revolutionary, it does mark a significant departure from the tribunal's original design. And as I previously mentioned and alluded to this briefly, that the tribunal's legacy jurisprudence, its bones are firmly rooted in the 1971 context. And this is quite a departure, taking the tribunal out of that context and applying it to this new situation, new atrocities, new context. And to me, it remains to be seen how the tribunal in fact performs in the future when a lot of its attention and a lot of care has been given to limit its remit to a very particular factual context. So one example that comes to mind is that to this point, the tribunal actually never prosecuted, both for judicial reasons and for political reasons, say individuals or perpetrators that were located outside Bangladesh. And one such group remains the former members of the West Pakistan Army. It was a very intentional move due to diplomatic, let's say, decisions why those individuals were never brought within the remit of the tribunal, or I should say the act. But that's really significantly changed. And it's really this expanded jurisdiction that has come in clutch to prosecute Sheikh Hasina, who, as I said, remains in exile in India. I'll move to the next few buckets, and the first one I'll mention is the alignment of the Act with now the Rome Statute. So we see that quite a lot has changed in Bangladesh since the 1971 context. You have in 2010, Bangladesh ratifies the Rome Statute. And yet the ICT Act sort of looked out of funk against what was its commitments at the international plane. So you had the tribunal stating that it's aligning its jurisprudence, keeping true to the text of the statute, but aligning itself to how standards are being developed under customary international law. It's reading in a lot of these requirements into its judgments. I explore these judgments in my paper. And yet it is still functioning off of narrow and outdated definitions. So we see that the amendments have now introduced new definitions of crimes against humanity, genocide, and harmonized modes of liability with Article 25 of the Rome Statute. Finally, I'll refer quickly to the last bucket, which is amendments and provisions that have been introduced that introduce much needed defense rights, such as free and confidential communication with counsel, access to interpreters, and notably the protection against self-incrimination. While I'm highlighting these few reforms, I'm also resisting the strong urge to overstate their novelty. And many of the reforms that I've highlighted just now, I would say are hardly groundbreaking. At best, they bring the tribunal or the act up to standards that international accountability mechanisms and bodies have considered basic nearly 10 to 15 years ago. In other words, I would say the reforms are less of a bold step and more of a late attempt at catching up. But what my paper really aims to explore also is that in this process of catching up, the Act has unintentionally opened doors to a fresh set of vulnerabilities. It takes the example, the paper engages with one of the examples, which is new provisions on digital evidence. So the Act takes a very permissive approach. It's this don't ask too many questions sort of approach. But the safeguards that one would expect in a world of deep fakes, AI manipulation, with the absolute necessity of airtight chains of custody, those safeguards remain aspirational. And in the context of the ICT, which is at the end of the day a domestic tribunal, this is quite problematic because the ICT within Bangladesh's own domestic setup functions on a different plane. So the tribunal is in fact not bound by the rules of evidence and other domestically available safeguards that would normally apply to, say, the High Court or the Supreme Court. So these safeguards are missing, and it remains to be seen how judgments are going to be delivered and how defense rights are going to be, or just the sanctity of the trial is going to be taken care of while these safeguards are not in place. Another pitfall or a separate category of pitfalls that I analyze is what I call them the stubborn remnants. And these include issues such as trials in absentia, along with the use of death penalty in trials that are being conducted in absentia. So we see that, in fact, in Sheikh Hasina's case. And these are two issues among many others that I talk about that have repeatedly drawn international criticism and continue to raise serious human rights violation concerns. So we see that these remain stubbornly intact within the Act. Now, perhaps one of the most troubling aspects of the Act remains that it is, or more than the Act, it's really the functioning of the tribunal, is that we see that the tribunal remains haunted by long-standing anxieties around judicial independence. We're seeing criticisms both on the bench and the bar side. So I think in conclusion, my takeaway can be summarized in a simple analogy, which is I see the acts and the reforms as changing of the curtains and rearranging of the furniture. But to me, the structural foundation of the tribunal continues to creak. And the risk, of course, is that this newly clothed tribunal is likely to reinforce the perception of victors' justice, then serve as a credible, durable model for accountability within the Asia-Pacific region. And this matters not just for Bangladesh, but also for the wider region. As we see Asia-Pac grapple with justice after transitional upheaval, to me, the ICT or the ICT Bangladesh stands as a reminder of both the possibilities, but also the perils of domestically led accountability. I'll stop there, Meg, and happy to take questions towards the end of the session.
Thank you, Tanisha. And yes, please, we so far don't have any questions in the Q&A, so participants, please start thinking of your questions. I think that was a very provocative overview of the perils of this approach. And also, I think you're recognizing the importance of domestic approaches to international criminal justice. And so there are lots of questions to be discussed there, but now I'll turn it over to Daly and we'll save those to the end.
Marvelous. I hope you can see what I can see, or at least what I'd like you to see. Thank you very much to Sehong, to the American Society of International Law. Good evening from Dubai. At the outset, I will apologize for any background noise. I'm fully on brand today for the University of Birmingham's 125th anniversary celebrations. So we have a VIP due to arrive at some point this evening, so do forgive any intrusion that enters through my headphones. So today I will speak to you about implementation of the Rome Statute of the International Criminal Court in the Pacific region. Again, it's another paper that was delivered thanks to the kind hosting of Sehong and Professor Simon Young at Hong Kong University earlier in the year in September. And it's a privilege to be able to present the paper again in this forum. So I'll begin with a roadmap for my next 12 to 15 minutes. I will start by giving you the origin story behind the paper, which will lead us nicely from the Asian continent to the Pacific region. I'll then talk a little bit about Pacific engagement with the Rome Statute system of justice, broadly understood. I'll then map the Pacific implementation landscape. That's the meat of the paper. And in conducting that mapping exercise, I'll reveal three manners or three categories into which one can put the Pacific states in terms of the extent to which they've implemented aspects of the Rome Statute in their domestic legal orders, the more comprehensive, crimes and cooperation, those in the halfway house, crimes without cooperation, and those who have yet to implement neither crimes nor cooperation. I'll end, or before concluding, I'll propose that the momentum towards including a fifth core international crime, namely a crime of ecocide in the Rome Statute regime, might provide a window of opportunity for Pacific states to turn their attention to implementing the core crimes that already form part of the Rome Statute system, but more importantly, to the cooperation mechanisms set out in the Rome Statute, without which the court simply cannot function. So, the origin story. 2014 to 15, I was working at the University of Nottingham. I'm now at the rival Midlands institution, Birmingham, but at that time I was loyal to Nottingham, where I was employed to work on a European Union and Royal Norwegian Ministry of Foreign Affairs funded project on implementing the Rome Statute of the International Criminal Court. We set up a database that you're welcome to dig into. I'll happily share the links to these as well in the chat when I'm done with this paper presentation. The National Implementing Legislation database, which is hosted on the International Criminal Court's legal tools page, as well as the Cooperation and Judicial Assistance database. So that whet my appetite for Rome Statute implementation issues. I then started my research a couple of years later after my second stint in Cambodia at the CCC, which has already been wonderfully introduced by Megumi earlier this evening, or this morning for you folks stateside. And I started my research on Asian states alongside my PhD, which I commenced in Hong Kong. And I published the findings of that in an article in the Chinese Journal of International Law. And again, I'll gladly share the link to that in the chat. This paper is the companion piece to that paper, which examined how states in Asia implement the Rome Statute of the International Criminal Court in their domestic legal orders. But my focus today, and for the purposes of this paper, rests on Pacific states. I spent the last 3 years at Macquarie Law School in Australia before relocating in the summer to the glorious United Arab Emirates. So by Pacific states, I refer to the 8 states that form part of the International Criminal Court's Asia-Pacific Regional Group. Cook Islands, Fiji, Kiribati, Marshall Islands, Nauru, Samoa, Timor-Leste. Again, we've had some introduction to Timor-Leste and its positioning in this region, and Vanuatu. But I did not choose to omit Australia and New Zealand from that, from the ambit of this study. Couple of reasons for that. So adopting a more inclusive approach and including these sort of regional leaders avoids the exclusion. It would be an artificial exclusion, I think, of 2 states whose experience has provided valuable impetus for other states in the region and could continue to do so. They simply appear in the Western European and others group for political voting reasons at the International Criminal Court. So I've adopted a broad approach to the Pacific for the purposes of this study. So the Pacific states have engaged with the Rome Statute system since its inception. Fiji was one of the first states to ratify the Rome Statute of the International Criminal Court after its framing in the Italian capital, and Kiribati was the most recent to do so in 2019. So Pacific states continue to engage also with the system. So that's the welcome message there to Kiribati. Though the number of states has increased since that time, the number of Asia-Pacific states hasn't. It remains static. I'd also note that the engagement stems beyond the Rome Statute to the Kampala amendments thereto, as well as the agreement on privileges and immunities that sit alongside the court and again enable its better functioning. And I, in the paper, position this engagement against a backdrop of unique regional vulnerabilities to which I will return when breaking down these states in terms of their engagement with the system. So what's required of states when implementing the Rome Statute? So the Rome Statute is really quite clear. Article 86 obliges, compels all states parties to cooperate fully with it in its investigation and prosecution of crimes within its jurisdiction. And Article 88 dives deeper and speaks to what must be done at domestic level. States are obligated to ensure that there are procedures available under their domestic law for all the forms of cooperation specified in Part 9 of the Rome Statute. So that, of course, extends to tasks such as arrest and surrender, but also to duties to consult with the court, for instance, to freeze the assets of individuals for whom the court has issued a warrant of arrest or summons to appear and has been accompanied by the requisite order under the relevant provisions in the Rome Statute and its rules of procedure and evidence. States are also able to implement the crimes set out in the Rome Statute of the International Criminal Court, but there's no equivalent obligation set out in the provisions of the court's constituent instrument to do so in the same manner as Article 88 sets out the obligation to ensure that domestic procedures align with what's set out in the treaty. So we now turn to the mapping exercise, and we begin with Australia, New Zealand, and Samoa, each of which has a dedicated implementing act. So a dedicated piece of legislation crafted, deliberately designed to discharge its obligation to cooperate with the court, to provide for those forms of cooperation, as well as to criminalize the crimes prescribed under the Rome Statute at a domestic level. This paper, I still need to conduct additional research to identify remaining gaps in relation to what these states have failed to include, or what might be missing, or what could be done otherwise. But notwithstanding the possibility that gaps continue to exist in that legislation vis-a-vis what is required under the Rome Statute, it's it's not too much of a leap to suggest that there may be lessons here for other Pacific states in terms of how they might go about conducting the implementation exercise. Other states, the majority of the states under this survey are states from common law jurisdictions with legislative processes remarkably similar to those of Australia, New Zealand and Samoa. And I suggest that there may be lessons to be learned. There may also be support that these states can provide. One of my conclusions in relation to the states that have failed to implement, this isn't a wrist-slapping exercise for those states, but an acknowledgement that capacity constraints have simply precluded them from doing so. It may be the case that, for instance, in the way that New Zealand has provided support to the Cook Islands in terms of its Rome Statute obligations to thus far, for instance, provision of a legislative drafter for states that lack such a role holder and so forth. Now we turn to our middle ground, our halfway house, partial progress, Fiji and Timor-Leste. Okay, so these two states have made some progress, but both have focused on implementing the crimes, or at least some of the crimes prescribed under the Rome Statute. So Fiji, in its crimes decree, has criminalized genocide, crimes against humanity, and certain war crimes. And Timor-Leste, in 2009 revisions to its penal code, has gone a step further, criminalizing genocide, crimes against humanity, war crimes, as well as certain aggression-related offences. But gaps remain, and my position is very much that the most critical gaps remain, because the most critical gaps are those that pertain to cooperation with the International Criminal Court, without which it cannot function. The International Criminal Court lacks its own police force. It has no capacity without state support and without legislation permitting such support to arrest individuals and to secure their surrender, to collect evidence, to, as I mentioned earlier, freeze assets or conduct other restraining measures on the territory of states without their support. And it's that absence of cooperation legislation that's particularly marked in relation to these two states. Now, final group, 50% of the states surveyed: the Cook Islands, Kiribati, Marshall Islands, Nauru, Vanuatu. I've mentioned that these states suffer from capacity constraints already. Some of them lack a legislative drafter, others have only one legislative drafter, and there are, as would be expected in systems with such constraints, competing legislative priorities. And it's perhaps arguable that implementing aspects of the Rome Statute regime aren't at the forefront in terms of those competing priorities. But what that means in practice is that these states are reliant on their general criminal law, their general criminal procedure, to execute requests for cooperation emanating from, issued by the International Criminal Court in The Hague. We move on now, though, to one potential solution, or let's say window of opportunity, termed by Darrell Robinson, I believe, in an article in the Journal of International Criminal Justice, the ecocide wave. So it was Vanuatu, Fiji and Samoa that were the three states parties to propose an amendment to the Rome Statute, which would see an independent crime, a fifth core international crime of ecocide, introduced within the court's subject matter jurisdiction. These states are therefore, at least there's some political will there, or maybe even strong political will, which has perhaps reopened attention to what is happening at the International Criminal Court. And my question or proposal here is, could that renewed attention create a window for implementation? If political will, and that's often what is most lacking in terms of implementation, has turned its attention to the Rome Statute in terms of its subject matter jurisdiction, then it's not such a leap from those early provisions in the Rome Statute that lay out the crimes that are prescribed under the court's treaty to Part 9 that lays out the cooperation mechanisms that states parties are required to ensure they have in place in order to facilitate cooperation with the International Criminal Court. At the same time, this regional momentum, these states are acting in concert in proposing this amendment to the Rome Statute. Could that facilitate pooled resources? Could that facilitate pooled expertise? Could the states that are lacking in terms of capacity pool their collective resources? Could the other states that I mentioned in the first group there perhaps also assist in this regard in terms of equipping the states in their region, their neighbors, with the requisite expertise and capacity to conduct an implementation exercise? Now, I'm almost at 14 minutes, so I'll wrap up with this. So my diagnosis really, particularly in relation to those that final batch of states, is that the non-implementation flows largely from structural impediments. It's not possible to conclude that these states have failed to engage with the Rome Statute system. They're states parties. When we compare it with Asia, and I can come back and say, I'll share that link in the chat momentarily, states parties in the Pacific have engaged with the system since the outset and continue to do so, most recently in relation to ecocide. But in terms of ratification, we see that spanning from 1999 until 2019. It's still moving in that space. And I won't say anything that's going to tread on Sehong's toes in relation to China's engagement with the ICC momentarily. But there are existing tools. There exists a model law on which these states, or most of these states at least, those of a similar common law tradition, could use as inspiration, as even a model on which they could draft their own implementing legislation. There also exist various ICC assistance programs. I receive the updates from the International Criminal Court in my inbox periodically. There was an Asia-Pacific States Parties Forum ever so recently. The court is equipped and prepared to assist states in doing what they need to do in relation to implementation. What I would emphasize here, though, is that sequencing is vital. So cooperation mechanisms are an operational necessity. Without requisite cooperation provisions in states' domestic law, the International Criminal Court simply cannot function as its architects intended. And for that reason, it's on these mechanisms, those set out in Part 9 of the Rome Statute, that all states, parties to the International Criminal Court, but for the purposes of this study, Pacific states ought to focus. And on that note, I will end, and I welcome your questions and comments in time. Thanks so much.
Thank you very much, Daly. I particularly appreciate the very practical focus and also the sense of maybe potential optimism in the potential for work on the crime of ecocide to galvanize some further implementation efforts. So let's turn now to Soo-Hong.
Thank you very much, Meg. Hello, everyone. After Megumi talking about Asian institutions, Tanisha talking about domestic tribunal in Bangladesh, and Daly talking about the implementation of the Rome Statute in the Pacific region, I would like to talk about the International Criminal Court in China, which is a major country in the Asia-Pacific region and is not a party to the ICC. I will start with the stance of China towards the ICC. Let's firstly go back to 1998. China was active during the negotiations of the Rome Statute. It had delegates serving as vice president of the Rome Conference and as members on the drafting and credentials committees. The deputy head of the Chinese delegation, Mr. Liu Daqun, he became a judge at the ICTY later. Despite China's contributions to the drafting of the Rome Statute itself, it voted against the final text due to several conflicts with its positions. And I concluded that there were 5 major reasons. The first was about the court's automatic jurisdiction, as there is no further requirements that states need to consent for the ICC to exercise jurisdiction. And also the member states cannot opt out from the jurisdiction of the ICC. And the second was that China was concerned about the prosecutor's proprio motu power. It considers there is insufficient check and balances on it. The third was about the scope of war crimes. China disagreed with the ICC's jurisdiction over war crimes committed in non-international armed conflicts. And the fourth was the definition of crimes against humanity, as there is no requirement that the state in which crimes against humanity are committed be at war. In China's view, peacetime offenses listed under crimes against humanity could belong to the area of human rights law. And the last major concern was about crime of aggression. China emphasized the exclusive role of the Security Council in determining if an act of aggression has occurred. After the Rome Statute entered into force, China showed an wait-and-see policy, and it showed an attitude to support and observe the work of the ICC. In October 2003, Chinese government made an official statement to express its consistent support of an independent, impartial, effective, and universal international criminal court. Since then, it has attended all the ICC annual assemblies of states parties as an observer state, and it has made statements as the general state of ICC ASPs. I would like to share some observations on those statements over the past 20 years. First, despite the various concerns not to join the ICC, I think China's general stance towards the ICC still seems to be supportive and consistent. For example, in 2009, it stated that China looks forward to contribute to the continued development of international criminal justice. And in 2024, it stated that China attaches great importance to the role played by international criminal judicial institutions in promoting international peace and realizing fairness and justice. I think the overall attitude is in conformity with the normative values about the decolonization process of developing countries and the maintenance of international peace and security. Besides, we can also distinguish it from the United States, as the general stance of China does not shift much due to the change of administration. Second, I conclude that China's core concern centers on state consent and sovereignty, which further connects to its disagreement on jurisdiction over nationals of non-state parties and its support for the principle of complementarity. For example, China expressed arguments on state consent regarding the situation in the Philippines in its statement in 2021. It criticized jurisdiction over nationals of non-state parties regarding the situation in Bangladesh, Myanmar in its statement in 2022. And it also supported domestic mechanisms regarding situation in Kenya and situation in Darfur, Sudan, respectively. Third, it seems that China's concern regarding the relationship between the ICC and the UN Security Council on the crime of aggression remains the same. It holds the same position as it did at the Rome Conference. Fourth, although it did not seem like a major concern why China did not accede to the Rome Statute in 1998, the Chinese government has reiterated the respect for immunity under general international law at the ICC ASPs, especially in recent years. It considers that under general international law, incumbent heads of states enjoy absolute immunity from criminal jurisdiction and inviolability. Paragraph 2, Article 27 of the Rome Statute, in China's view, can only apply to state parties and should not bind non-state parties. Otherwise, it could be contrary to the principle that the treaty does not apply to a third state without its consent. China further refers to Article 98 of the Rome Statute that the court may not proceed with the request for surrender or assistance, which would require the requested state to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state. On a related matter, the PRC Foreign State Immunity Law was adopted in September 2023 and became effective on the first day of 2024. In particular, under this foreign state immunity law, foreign state, including an individual authorized by a foreign sovereign state that exercises sovereign authority and conducts activities in accordance with such authorization, enjoy immunity from the jurisdiction of the PRC courts, with some exceptions, mostly concerning commercial activities. The law does not include any provision on criminal matters. However, Article 22 of this law provides that where an international treaty to which the PRC is a contracting or acceding party provides otherwise, the provisions of the international treaty shall apply. That means that although China seems to have a traditional and conservative view on immunity, this law itself does not create specific legal barriers for China to accede to the Rome Statute in the future. And last, China has not developed a genuine trust in the ICC for avoiding double standard and selective justice. It stated in 2024 that it's our hope that the court will adhere to the mandate of the Rome Statute, lawfully perform its duties, strictly follow the principles of complementarity and international cooperation, uphold an objective and impartial stance, and exclude political interference, interpret and apply the statute and general international law comprehensively in good faith and with uniform standards. This is an overview of the stance of China towards the ICC. Like at the end of the Rome Conference and through the statements the delegates has made over the years. Now I would like to turn to the interactions regarding China and the ICC. As a permanent member of the Security Council, China played some role in referrals and deferrals of cases to and from the ICC. We know that as so far there have been 2 situations that have been referred by the Security Council to the ICC, including Darfur, Sudan, and Libya. For the Darfur, Sudan situation, China abstained in 2005. However, it stated that China would have preferred that the perpetrators stand trial in Sudanese courts, and China did not favor the referral to the International Criminal Court without the consent of the Sudanese government. I think at that time, China was very cautious to abstain. It could be because it was the first time to have such a discussion, and China just did not want to block it. The other one is the Libya situation. China supported the referral of the Libya situation to the ICC in 2011. But I think that's a exception for the very severe and special circumstances in Libya, and does not reveal that China has changed its general positions about state consent and sovereignty. As the Chinese delegate stated at that time, China is still in favor of peaceful means such as dialogue. And he mentioned that the safety and interest of foreign nationals in Libya must be assured. I think that might be the reason why China supported the situation. It was more concerned about the interest and investments by Chinese nationals in Libya during that time. And another example would be Syria. China vetoed in the discussion about referring the Syria situation to the ICC, so that's one that did not pass. In 2014, the delegate stated that any action seeking referral to the International Criminal Court should be based on the premise of respect for the judicial sovereignty of states and the principle of complementarity. Forcefully referring the situation to the court in the current environment was neither conducive to building trust nor to the resumption of negotiations in Geneva. And after talking about the referrals, I also want to talk about one example about deferral. In 2013, China supported the discussion about the deferral of the Kenya situation from the ICC. But that resolution did not pass because like other states disagreed. And I think it's the support of the deferral is consistent with its positions about the referrals that it did not agree with. And in the end, I would also like to talk about non-official interactions in the world of international law. Although states are major actors, contributions and impacts regarding individuals should not be neglected. The ICC had a vision to promote international criminal law in the 6 UN official languages and reach global audiences. Currently, ICC moot court competitions are organized in English, Spanish, French, and Chinese, with a view to also support an Arabic version in the future. The Russian version was organized before, but has been discontinued. The ICC Moot Court competition in Chinese was firstly held in 2012, competed by 13 teams from mainland China. Its size and influence kept growing over the years, involving universities in mainland China, Hong Kong, Macau, Taiwan, and other countries and places where Chinese is a popular language. In the last competition in 2025, 106 universities participated in the preliminary stage of the ICC Moot Court Chinese version. Every year, at least hundreds of students who speak Chinese get exposed to international criminal law through the ICC Moot Court Chinese version, and they may develop interests in this area for their future career. Besides, although China is not a state party to the ICC, there have been several Chinese nationals working as full-time staff members at the court, serving different divisions of the registry. Young generations of Chinese lawyers, especially those who participated in ICC moot court competitions, have shown strong interest in internship programs at the ICC and have contributed to the work of various branches, including the chambers, the office of the prosecutor, and the registry. I think through more such non-official engagements, it will be helpful for the ICC to promote international criminal justice in the Asia-Pacific region. And I will stop here. Many thanks for your attention.
Thank you, Suhong. And I'm glad that you are focused on this question because obviously the role of China in the world generally is increasing exponentially, I would say, at the moment. And so the importance of that country's engagement with international criminal law is hard to overstate in terms of the future of the regime. So we've had some very interesting presentations on different aspects of the engagement of actors in the Asia-Pacific region with international criminal law. And I'd like to start off our Q&A with a general question to the panelists, and I'm going to also kind of weave in the one question that we have so far from the audience. And the general question is kind of related to something that I spoke about at our conference in Hong Kong, which is the changing role of international criminal law in the world in light of the rise of multipolarity. So as power is becoming, in some ways, more diffuse, more actors have the opportunity, I think, to, and this is a thesis with which, of course, you are welcome to disagree, but to contribute meaningfully to the development and impact of the international criminal law regime. And I think it's also notable at the moment that, Suhong, you talked about some of the ways that China is engaging. We also at the moment have the United States actively fighting the International Criminal Court through the use of a sort of unprecedented use of sanctions that are meant to curtail human rights abuses, instead being levied at the judges and prosecutor at the International Criminal Court. So I wonder if the panelists have thoughts about kind of this general question of, in this new world of multipolar power, what are some of the ways that the Asian region can specifically contribute to the development and implementation of international criminal law? And I'll add to that the question from advocate Sushant Kohli from India about enforcement, and what are the ways in which this regime can be enforced when there is non-compliance. So who would like to start us off? Thanks, Megumi, over to you.
Thank you for the exciting questions. I would like to answer the first one with the issue of multipolarity. I was thinking, and I partly referred in my presentation, that the jurisprudence or the legal findings are often not really be welcomed or being researched I probably think that the cause for this ignorance among scholars might be due to certain biases that we have. Obviously, there's a political interference and scandals and financial problems, like a lot of limitations. I believe at the same time that the judges in the bench with the legal background must have must have paid a lot of effort to find laws and apply the law to the facts. And I believe that in this multipolar world where the ICC might take the lead, but at the same time, the most of the cases will go to domestic cases. We as the scholars should pay more attention and take them seriously. Them here means the jurisprudence coming from each state that is applying international criminal law, and the judges, domestic judges, even they try to really learn international criminal law and apply them. Maybe those students who have attended the moot court that Suhon already mentioned, new generations are now international criminal law native, and I hope to see the generations working at their domestic courts even, and those legal inputs should be taken seriously. And for the issue of enforcement, I just wanted to say today we didn't really have time to talk about the practice of cooperation with the ICC, but I want to lead your attention to the recent development of the Philippines that surrendered former President Duterte to the ICC. And I know some the lawyers in the Philippines working with the victims, they were really took the key role in evidence collection and finding the witnesses and so on. So those local younger generations' input will lead to future enforcement. So in this point of view, I see the brighter future. Maybe I'm too opportunistic, but I want to start from that perspective. And now I would like to pass the floor to the other participants. Thank you.
Thank you, Megumi. And I think that your comments about the importance of national implementation and enforcement leads us nicely to going over to Daly and then Tanisha, both of whom have focused on some of those national efforts.
Thank you very much indeed for the question. Yeah, absolutely. So there isn't a single world government or global police force responsible for enforcing international law. And I guess one of the focuses of my paper is on what is then required, what can assist in the enforcement of international law. So states will incorporate international law into their national legislation, whether automatically or by transposing it through a dedicated act, like some of those to which are referred in common law jurisdictions in the presentation, and then it will be enforced at that level. For certain serious violations, the ones that we've been speaking about today, or at least the subject matter that rests behind everything that we've been addressing today, genocide, crimes against humanity, war crimes, we may see enforcement occurring through international institutions, but again, at the behest of the state's parties that can actually execute warrants of arrest and collect evidence and so forth in on their domestic territories. So how do we improve that? Well, strengthening domestic implementation and execution of international obligations is one way. Establishment of specialized investigative units is something that we've seen in international criminal law recently. Enhancing international cooperation, both with respect to international crimes, but also transnational crimes. So strengthening mutual legal assistance frameworks that might relate to asset recovery frameworks, extradition practices, and so forth. And then, of course, supporting international courts would be one way, right? Ensuring cooperation with the International Criminal Court and other accountability mechanisms. If I can offer one additional comment on the contribution of Asia before wrapping up this sort of response, I'd suggest that the region's expanding scholarly community is also capable of shaping the direction of the field. Events like this, where we can see Asian scholarship or scholarship focused on Asia on show. So kudos to the American Society of International Law for organizing this. That allows us to diversify the intellectual foundations of international criminal law, and we can see alternative frames being engaged with, third world approaches to international law, post-colonial frames, indigenous legal traditions, particularly when I'm speaking about the Pacific states today. And then I think that builds nicely on what Suhong mentioned in relation to the International Criminal Court's moot court competition. So, and also what Megumi mentioned there in relation to focusing on the generation of jurisprudence in Asia. So we can go beyond cases, we can go beyond institutions to the generation of ideas and concepts and approaches like the theory that Megumi's presented in her work earlier today. So on that note, I'll end.
Thank you, Daly, for those helpful thoughts about various ways in which even this very effort might be contributing to the cause. So appreciate it. As I turn it over to Tanisha, I just want to also wrap into your general answer to the general question, a question that we've gotten in the Q&A specifically to you about why the government of Bangladesh didn't create a hybrid tribunal, cooperate with the United Nations in the way that, for example, Cambodia did with the ECCC. So perhaps you could weave that into your answer to the general question. Thanks.
Sure. So I think just first on the broader question, and I find it quite fascinating in my own practice to see how, both academically and in practice, how states have in the region have interacted with international criminal law, high crimes, and you have this one stream where you see the key players in Asia taking such a integral role in shaping up the Rome Statute. So you have, the references that Suhang made to how China participated. The story was not very different from India. For India, had a key role to the end and decided to actually not ratify because of several issues that it identified with the drafts. And then you see from that stage, states sort of taking a step back, these key players taking a step back. That leaves you with states that are party to the Rome Statute, yet take that passive position. A lot of them, perhaps because of capacity constraints, as Daly mentioned. And then you have this rare bunch, which is the active sort of states that engage with the ICC or international criminal law more actively. I think Bangladesh falls in that category insofar as it has engaged with say, the fact-finding missions and engaged with the court in terms of the Rohingya crisis. But the problem I see with say, Bangladesh in that context is there are concerns still as to whether that engagement is highly selective and politicized. So there are questions critics are asking why, say, the 2024 atrocities are not being referred to the court. And I think one of the reasons that I would speculate would be this issue of ownership. And let me use this as a segue to answer the question about the Bangladesh tribunal and why didn't they come up with a hybrid tribunal. So if you look into the history of the act, there were in fact Bangladeshi leaders entered into discussions with the Secretary General back in the day to see if there was scope to in fact set up some sort of international tribunal, hybrid tribunal, refer it to a mechanism. There wasn't concrete discussions about what the tribunal would have looked like, but there were discussions about bringing the international community together to set up a tribunal that would have looked wildly different from what we have today. One of the reasons that a lot of the academicians cite is that there was the drive for a new independent state like Bangladesh to take ownership of its own prosecution. A lot of the crimes, that were committed during the phase of the 9 months of the War of Independence actually led to a breakdown within Bangladeshi society. If you go to Dhaka, in fact, you will see a lot of relics from the war. You have a lot of museums and you have all these establishments and pieces of history that are left behind that mark an attempt at restorative justice. And in many ways, to me, this tribunal has been a success insofar as even 40 years later, there was still an attempt to talk about, engage with history that many of the individuals who are sort of engaging, watching it online or hearing about it or reading about it, never actually lived through. So there was this tension, I would say, between owning the process, but also living through a time in the 70s. Like I said, it was the period of silence where the international community hadn't really found its footing of bringing mechanisms together, shaping it up. And obviously these things take a lot of time. Some of the biggest criticisms against hybrid tribunals is that you're looking elsewhere for money, you're looking elsewhere for technical know-how. Seems like Bangladesh felt that it was confident enough to set something together, put the brains and the money and the thinking and own the process. So I think that's really one of many reasons why they did not come up with the hybrid tribunal. Now, just to sort of round off my comment, I started by saying that I find the interaction of Asian states very fascinating and telling. What I want to highlight in closing is how these very Asian states are interacting with international criminal law, I should say high crimes, in other forums. So you see states still actively engaging in the Sixth Committee at the UN on crimes against humanity drafts. You still have most of these states that have ratified the Genocide Convention. You see many of these Asian states actively participating in cases before the ICJ. So there is still engagement with the topic. To me, it's this very calculated move of optics, which includes optics, as the engaging when it comes to high crimes and issues of accountability. I see this as a moment of reflection, calibration, where states, and I may be generalizing, but many states in the region are realizing that they need these instruments, they need these institutions, but they're still figuring out to what extent that they're comfortable to engage with them. For many states in Asia, it's their first time. How many states have really engaged with processes before international courts? Not that many. And it's an issue of capacity, it's an issue of experience. You will never see these states being called repeat players before courts like at the ICC and the ICJ. So I think a lot of comfort also comes with engaging in processes. With the ICJ, for example, you can, submit one document that goes in support of the main case as an interested party. And that can be sort of the beginning and the end of your engagement. Whereas with the ICC processes or with a hybrid tribunal, it's far more engaged. To start and see the process through is a huge commitment that many states may not be willing to undertake. So in closing, I think, states are realizing that they need to engage. There's no world in which they cannot engage, be that in the UN, in the safety of diplomatic rooms, or be that in courts. They're trying to figure it out, or at least that's what I would like to believe.
Thank you so much, Seisha. And we just have a couple of minutes left. So, Suhong, perhaps you could say something about the general question and maybe quickly say something about the immunity question that was raised. What can we do about enforcement in a world where there's still some recognition of immunities?
Sure. I think for the future of international criminal justice in the current multipolar world, we may think about, like two ways. One is to increasing the capacity of domestic prosecutions and thinking about alternative ways, such as truth commissions and victims reparations, because we need to think about like the diverse culture and needs in different places of the world, and also to develop the rule of law building in the world. And the other way that we may think about the future of international criminal justice is the scope of international criminal justice itself. Because I think now, like, we are more focused on the four core crimes, which we consider as international crimes. But the concept of international crimes can also develop. Like now we are thinking about ecocide, and we may also, think about more transnational crimes, which have a global impact and which also, endanger human rights seriously. So those are my two comments to the general question. And for immunity, I want to mention that within the regime of the ICC, there is no immunity granted for violation for international crimes. But for those countries who are not parties to the ICC, they may still have their traditional views on immunity, and also even for even for some states who are already parties of the ICC, they may not fully cooperate with such requests, as they still have concerns over the traditional international law. And I think that the concept of customary international law is also developing. It's based on opinion juries and state practice. So in the future, I think there is possibility that there can be new customary international law about international crimes and the issue of immunity.
Thank you so much. Well, I know that the participants are joining me in thanking the audience. The audience is joining me in thanking the participants, and also we all thank the American Society of International Law, Sue Hong in particular, for organizing really generative discussion. And I hope that we will continue to communicate with one another along these lines and to encourage this agenda moving